Okay, we are recording. So let's see. So today's presentation, like I said, it's going to be about 45 minutes long, estate planning during COVID-19. So my name is Clemons. I'm going to start my video and share my screen. You can see me at the top right of your screen. So my background is in taxation. I have my master's in taxation law, and we're going to be discussing tax quite a bit today, as well as general estate planning. Presentation should be about 45 minutes long. And after today's presentation, I'm going to offer question and answers. You can go ahead and type in questions and answers as you like. I will see them as we do. And if I think that they're appropriate questions, I'll answer them as we go along with this presentation today. I do want to give you some, I guess, guidance of where we're going. We're going to talk about the Cunningham Legal story. We're going to talk about our locations. We're going to talk about our staff. And then we're going to go into substance. So estate planning. And that's going to be what happens when somebody passes away. What happens if somebody becomes incapacitated? And we're going to talk about trust administration. What happens when somebody dies? A lot of people, they've been doing estate planning their whole life, but they've never actually seen somebody pass away with a trust in place. What happens then? And then finally, we're going to go over financial planning mistakes that we commonly see, just things in 2020 that people could probably generally improve on. Now, everything we talk about today is purely for educational purposes only. Everything we talk about, it is not legal advice, educational purposes only. After today's presentation, everybody who's attending this presentation, you'll be offered the chance to meet with me one-on-one at a later date, either via Zoom or in our office. So if you do have these specific questions and you're seeking legal advice, I encourage you to take an appointment. All right, so our firm, Cunningham Legal, we have 7 different attorneys. You can see our founder, Jim Cunningham, on the top left. Jim wrote a best-selling book on estate planning called Savvy Estate Planning, which is on Amazon.com, a really great read, really easy read. We have clients all the time who find this law firm because of that book. And then you have myself, Clemons. Like I said, my background is in taxation, my master's in taxation law from Loyola Law School. But of course, I do estate planning. And estate planning, like I said, it's preparing for incapacity, preparing for death. I work in our Pasadena office. We have offices throughout California, Orange County, LA County, Sacramento area. And we also meet via Zoom. That's what we've been doing during this whole COVID process, is we've been meeting our clients via Zoom. We've been signing via Zoom. We've been recording our clients via Zoom. And it's been a really interesting couple of months. Now, our firm is broken into estate planning and trust administration. Estate planning, that's going to be preparing for death, incapacity. Trust administration is what happens afterwards. So let's get into the actual substance. So estate planning, what do I mean by that? Well, when people think of estate planning, they oftentimes think of documents. They think of a trust, a will, a power of attorney, healthcare documents as well. And I will be touching on each one of those at some point today. But at our firm, we really don't pay as much attention to the documents. We really focus on the process. Are our clients preparing for all the types of things that can happen? Incapacity versus death, for example. I probably don't need to tell you. You've probably seen it in your own life. The majority of people, they become incapacitated in one way or another before they pass away. So I guess their bodies outlive their mind. We see that all the time. And so all the time, we see families where somebody has to pick up where another person left off. They have to manage the assets of another person. And so is your estate plan written that way to address that issue? So I'll give you an example of what I mean. I had a client a year or two ago who came into my office. She lives in Arcadia. She's 90 years old. She came with her daughter, also lives in the area. And I reviewed their 2005 trust they had in place. And the first thing I noticed in this trust was that the son in North Carolina of my client, he was a successor trustee, not the daughter who was at my meeting. And so I found that to be a little bit unusual. So I asked the client, why did you name your son in North Carolina as your successor trustee? And she looked at me like I was crazy. And she said, well, one day I'm going to pass away. And my son, he's going to fly here from North Carolina. And he's going to sell my house and split the proceeds among my 3 children. And so I said, that sounds like a great plan if you pass away. But what happens if you become incapacitated? What happens if you need somebody to pay your bills or get your mail before that time? And she said, well, obviously that would be my daughter here in Arcadia. She would take care of me. But her estate plan, her trust was not written that way. She had her son as her successor, regardless of whether she was incapacitated or deceased. And we changed her estate plan. We restated it. We kept it so that her son, he controls the finances in the case that she passes away, but her daughter, she manages finances in the case her mother is incapacitated. So making sure that you name a trustee for the correct situation doesn't make a ton of sense to name a successor trustee for incapacity purposes if your successor trustee lives on the other side of the country or in another country altogether. So make sure that you look at your plan in those different ways. Now, all that being said, you should also make sure that you're tracking assets. So I have clients come into my office all the time, and they put down their big estate planning binder on my desk, and they look at me and they say, well, what do you think of this? I spent $4,000 on it. And before I even look at their binder, I ask them, is your house deeded to your trust? And quite often the clients say, no, it's not. I refinanced, I took it out, or I think my attorney, they never actually deeded it to the trust. Well, if that client passes away right there, California doesn't care how much money they've spent on their trust. They don't care how many attorneys have seen the trust. If the house is not deeded to the name of the trust, the house will potentially go to probate. We'll come back to probate in a little bit, but that's the whole purpose of having a trust in the first place, is to avoid probate. You have to make sure that your assets are actually titled to the trust. This is called funding the trust. And I'll come back to this throughout the day. You also have to make sure that your bank accounts are in trust too. Now, I know there might be somebody watching this virtual workshop who's saying to themselves, Connor, I don't need to put my bank accounts in trust. I have my children as my beneficiaries on my bank accounts. And that works sometimes pretty darn well if we know that you're going to pass away. But like I said earlier, probably the majority of our clients, they become incapacitated before they pass away. They need their trustee, their successor, to manage those assets. And if the accounts aren't in trust, trustee will not have access to the assets. So what does that mean? Well, that means that they can't go to the bank and they can't pay your bills. They can't use your money to pay your medical bills or whatever it is. They have to be in trust. If they just have a beneficiary, they won't have access, the beneficiaries, to the account until they have your death certificate. So make sure that you keep your assets in trust. And we will come back to that, like I said. So in estate planning, everybody has a unique story. And the unique story that I hear most is the story of probate. And I don't know if you've ever been through a probate, but probate has a particularly bad rap in California. What is probate for those who have never been through it? So probate is the court process where the court oversees the distribution of assets from a deceased person to living people. So it's a court process, so keep that in mind. And so it's unpopular for really two reasons. The first reason is probate is a long process. So probate in LA County is generally about 1.5 years. You know, you oftentimes hear about it going for 2 years. And you probably think to yourself, well, what can be happening for 1.5 years? Well, it's a very form-driven process. It's a lot of waiting around for court dates. So look at people who die right now and who have to go through probate. LA County courts, they aren't doing probates right now. You have to wait, and that type of stuff happens. And so probate is unattractive because it takes so long, but for most people, what they think of when they think about probate is the high fees, the high legal fees. Now, I have the $1 million estate memorized. All the fees are based off the size of the estate. And so $1 million estate, that doesn't mean that you have $1 million in equity. It means you have assets worth $1 million. So if you have a house worth $1 million, regardless of what type of debt you have, they say you have $1 million estate. And on $1 million estate, your attorney's fees, they're automatic. They're $23,000. Your executor, they are paid $23,000 as well. And then the court fees are at least $1,900. So this probate on this $1 million estate, regardless of how much actual value is in the estate, probate fees are going to be about $50,000 on a $1 million estate, which we see all the time. And so people try to avoid probate. And how do they do that? Well, they set up a trust. That's why you probably know people, if you don't have a trust yourself, who have trusts, because they're trying to avoid probate. That's the real traditional reason why people use trusts instead of wills. See, the probate threshold in California is $166,250. And so what that really means is if you own a house in California, you are subject to probate. So what is a trust? How does a trust work? How does a trust avoid probate? Well, a trust is a vessel, and it started by you. You are the grantor. So you are the grantor. That means that you started the trust. It's also known as a trustor or a settler. And during your lifetime, you fund your trust, just like I talked about earlier. You deed your property to your trust. You deed your bank accounts to your trust. You deed your brokerage account to the trust. Your stuff is in the trust. How about retirement accounts? Are retirement accounts in the trust? No, retirement accounts stay out. We'll come back to that in a little bit, but that's a trick question. They generally stay out. Now, you are the trustee of the trust. When I say trustee, that means you are the human representative of the trust. So you make your decisions as to how to spend your money. And you make your decisions as what stuff to sell. But one day, you know you're going to become incapacitated, or you know you will pass away. And so you name a successor trustee, somebody who's going to make these financial decisions for you if you cannot do so yourself. And that's a very intimate position because they're going to decide what type of long-term care you receive if you need it. They're going to decide whether to sell your house and to downsize you. They're going to decide which stock to sell and when to sell it. So it's a very personal, intimate position, and you need to pick somebody you trust as your successor trustee. Now, while you live, you are the beneficiary of the trust. That means all the money's yours. Even if somebody else is managing the money's yours. But once you pass away, you have new beneficiaries. Maybe it's your kids or your siblings or your friends. But at that time, the trust, the vessel, even though you're deceased, the vessel is still living in the eyes of the court. And the distribution is made from your trustee to your beneficiaries. And that's how probate is avoided, because there's never the involvement of a deceased person. It's a living person, the trust, to living beneficiaries. Okay? So I keep talking about this concept of trustee. How do you pick a good trustee? Well, believe it or not, the big factor is going to be trust. So I went on to Google and I typed in who is the most trustworthy person in America. And Google, they told me that person is Tom Hanks. So Tom Hanks, he's going to be my go-to trustee. Really trustworthy guy, and he's probably pretty competent as well. That's another factor when you want to pick a trustee. I have people that come into my office quite often who say, I have 3 wonderful kids, but I don't think any of them can pay my bills. I don't think they know how. So in that case, even if you trust your person, you might not want them as your successor trustee. Competence is an important factor. Also, like I talked about earlier, proximity, that plays a factor as well. You want to make sure that whoever your trustee is, they can get your mail if they need to do it. And then I also have clients who say, you know, I have 3 wonderful kids and I trust all of them and they're all really competent and they all live in Arcadia. And I don't know who to pick. I might just want to pick all 3. Well, a lot of attorneys would tell you that if you really have that great of a situation, co-trustees, we would rather see you just pick one of them as trustee, the one who communicates best. That's really the last factor, communication. It's important that you pick a trustee who communicates best. Now, not everybody has a person in their life that they trust to make these important decisions. You can also hire a trust company or a fiduciary to act as trustee. Our law firm, Cunningham Legal, we do not act as trustee. It's a totally different profession, but we can definitely recommend people either in the area or we can recommend trust companies oftentimes in Nevada, because in Nevada, they have low fiduciary fees, no state income tax. So there's plenty of benefits to go to Nevada as well. All right, so let's switch gears. I see no questions or answers coming in so far, but if you'd like to ask, this is an appropriate time. Now, back in the 90s, early 2000s, if you were married and you had a trust, you probably had what's called an A-B trust. So I told you we would talk about different taxes today. The first tax we're going to talk about is estate tax. This is also known as the death tax. And there's always been an estate tax, at least in modern times, and there still is. Back in the day, there was an estate tax on people worth $600,000. So what that means is if you died and you were worth $600,000 or more, the government wanted a cut of your estate. They wanted another tax. And that tax still exists today, but it's not $600,000. So back in the day, back in the 90s, for example, when we had a married couple, we would split the trust when the first spouse died into an A trust, into a B trust. And there were lots of complicated issues around that. You know, the surviving spouse has to live with two trusts. They have to file two separate tax returns. The kids, they don't get a step up in basis on what they inherit from the B trust. So my whole point is there's all these downsides, but the whole benefit was to avoid estate tax. Well, today in the year 2020, the estate tax exemption is no longer $600,000. It's now $11.58 million, $11.58 million. So it's very high. So nobody has this estate tax issue unless you're pretty much very wealthy. Now that number, of course, is very fluid. It can go up and it can go down. That 11.58, it probably will go down based on what's happening in the world right now. But all that being said, $600,000, those days are long gone. So if you have an AB trust, there's a great chance that you should renew it. Right now, when we have clients who die with this AB trust in place, we oftentimes go to court. I mean, really, we always go to court to get rid of that B trust. Because the B trust, going through that split, it just doesn't make sense. The tax savings aren't there anymore. It's an outdated trust. So if you have an AB trust, if you have a trust that was drafted before 2005, certainly make an appointment so we can review it and let you know what you need to do. Even if it's after 2005 and you're married, maybe just double check to make sure you don't have to go through that split when the first spouse dies. Do you have a trust protector in place? This is another feature that's come around the last 20 years that's really starting to become an industry standard. So what is a trust protector? Well, the majority of our clients, they name Cunningham Legal or an attorney with Cunningham Legal to be their trust protector. So what that means is we can change the trust if need be. We can define things that are vague or ambiguous. So I'll give you an example. A common change we see is name changes. So let's pretend that you and your spouse, you name your daughter as your successor trustee, and your daughter, your last name is Mendoza, but she gets married after you sign the trust to somebody named Lee, and she changes her name from Mendoza to Lee. Well, at that point, the documents are somewhat outdated, and if you actually pass away, we would potentially have to go to court in order to change the documents. But when you use a trust protector, the trust protector can change the documents. They can update the trust so that the trustee's name is no longer Mendoza, it's now Lee. And that allows a quick and cheaper change to the trust. And I mean, especially right now with the whole COVID situation, like I said earlier, the courts are really closed. Or excuse me, for our purposes, they're essentially closed. Everything's delayed. So any question we have is delayed. So my point is that trust protector, we can change things like names without getting any court permission. Now, I did see someone raise their hand on my notification here. If you have a question, you can type in your question on the Q&A box. So going back to trust protectors, so you can change names. You can also change the trust, like let's say some type of tax law is passed. We can potentially update the trust so that the trust doesn't have that outdated law. You don't have to get court permission. Trust protector has the flexibility to do it. All right, I do see someone with a question saying, I have a $300,000 annuity. Should this be part of the trust? So I'm going to come back to it. And first of all, that question, I'm going to come back to retirement accounts. Question's a little bit specific, but generally speaking, no, and I will come back to this. All right, and then finally, with trust protector. Trust protector really was introduced for asset protection reasons. Now, for years, people have been coming to attorneys like myself, and they have been asking, how do I protect my kids' inheritance in the event of divorce? Asset protection, really general. And for years, attorneys would say the same thing. Attorneys would say that as soon as your child inherits the money, as soon as they get that money, make sure they put it in a separate bank account away from their spouse. That way, if there ever is a divorce, they can trace what was their separate property from the inheritance. Well, what's the issue with that? It's a lot easier said than done. It can be very difficult for a lot of people to inherit money, like $500,000, and then tell their spouse, this money's my separate property. I'm going to keep it in a separate bank account away from you. I'm going to set up my own separate estate plan. I'm going to put the kids as beneficiary. My brother will be the trustee. That doesn't always happen. Usually it does not happen because it creates an awkward dynamic in the marriage. It offends one of the spouses. Usually one of the spouses has more control than the other. And so my point is, we don't like to leave money outright to people because it puts too much pressure on that one spouse. So what do? We prefer to leave money to a continuing trust instead. So I'm going to go through several continuing trusts. Our first continuing trust is called an inheritance protection trust. This is our most popular feature at Cunningham Legal. Now, this is a trust within the trust. It's created after our client passes away. So we have Judy here. Judy is a doctor. She practices medicine. She's in a shaky marriage, and her parents know she's in a shaky marriage. Judy's parents are our clients, and they want to leave her $500,000. They do not want to leave it to her, though, inside a direct distribution, because they know that she's at risk of getting a divorce. They know she's at risk of getting sued, practicing medicine, medical malpractice. So they leave her money to this inheritance protection trust. Now, the inheritance protection trust, this is like a separate bank account. So what that means is Judy, she gets this money inside this bank account. She's trustee. She can manage the money. But if Judy wants asset protection, she resigns as trustee. So when she's trustee, she can go to the bank. She can pull out all the money in the world. But when she's not trustee, the trust is written so that distributions are discretionary to the trustee. And when Judy resigns as trustee, the trust protector, so Cunningham Legal, we name a new trustee, somebody who Judy wants, maybe her financial advisor, somebody who's not her relative. Because if she's not trustee, she has asset protection. If she gets sued or divorced, she can't find out what type of asset she has because she's not a trustee. She can't go to the bank and she can't request to see her account balance. She's not a trustee. If she asks her trustee to distribute money to her, the trustee doesn't have to do so because distributions are discretionary to the trustee. So this trust, it provides that asset protection for beneficiaries, really outstanding asset protection. And like I said, you start leaving distributions to your kids of $500,000 or more, you should certainly consider the inheritance protection trust because this is becoming the standard in estate planning. Now, our next trust is called a Dole-it-Out Trust. This is a trust for spendthrift children. It's not nearly as common as the inheritance protection trust, but it still has a place in estate planning. So the Dole-it-Out Trust, how this works is you have a beneficiary who isn't great at managing money, just like our client, Chris, here. So Chris, he's never worked a high-paying job. His wife is a homemaker, and they've never had the chance to manage a lot of money. So his parents know that if he inherits money, he'll probably spend it pretty quick, whether it be on a boat or a car or something that depreciates. So Chris's parents, they leave him his money through what's called a Dole-it-Out Trust. So this is a special type of trust where the money is managed by somebody besides Chris. The money is distributed oftentimes on a monthly basis, maybe $2,000 a month, maybe $3,000 a month. Now, if Chris spends it, it's not the end of the world because he'll get another check the next month. And maybe in the meantime, he will learn some money management skills. The money that sits in trust, it continues to grow. The principal continues to grow. And because Chris is never trustee of this trust, it has excellent asset protection. If he gets divorced, if he gets sued, if he has his own creditors via debt issues, he has asset protection on that inheritance. So that is called the Dole-it-Out Trust. That is another common feature that we use for spendthrift children. Our final continuing trust is a special needs trust. You might have heard of a special needs trust before. And this is for people who receive government means tested benefits. Medi-Cal is the big one in California. And for anyone who's ever worked with Medi-Cal, you know that if you continuously have $2,000 in your bank account over the course of a month, you risk losing your money. You lose, your Medi-Cal, you lose the Medi-Cal potentially. And so our beneficiaries who receive this Medi-Cal, they can't inherit money because they'll lose that Medi-Cal. So what we do is we leave that money to a special needs trust. This is a different type of trust altogether. Now, this money is not managed by the beneficiary, nor does it get paid out to the beneficiary. This trust is managed by somebody else, and it allows the beneficiary to keep their Medi-Cal or their SSDI or whatever it is that they receive. Now, that money stays in trust, and it can go to pay directly for the beneficiary's needs, like housing and food and vacations, things that will not disqualify the beneficiary from the means tested benefits. Now, oftentimes our beneficiaries, our special needs beneficiaries, when they pass away, there's still money left in their special needs trust. And if that is the case, our clients are able to dictate where that money goes after their special needs child passes away. So if you have a special needs child, It is important to make sure that you plan for their needs because you do not want to have their benefits risk being taken away. All right, so I'm going to shift gears yet again. Oh, look, I do have a question. I'd like to answer it. Let's see. So I'm going to read this out loud. If I want to give my investment account to my daughter while I'm alive, which is worth $1 million, how do I do it? Besides IRS Form 709, any legal paperwork, can your company do it for me? All right, so this is another kind of specific question. Well, this is why we do these one-on-one deals. But let's talk a little bit about that. Gifting to people while you're alive. Why do people not do that? Why do more people not gift while you're alive? Well, there's a concept in taxation called basis. So I'm going to shift gears before I go on to healthcare. So let's say you have $1 million brokerage account, $1 million. Now you have a basis in this brokerage account, okay? Now your basis is how much you acquired this stock for. So if you have $1 million brokerage account, your basis might be $300,000. So if you sold your brokerage account, you would have $700,000 in gain. And in this state, California, you pay 15% to the feds on any capital gains, and then you pay another amount to California. 9.3 is a very common amount. But of course, if you make more money than the average person, that number goes up. So about 24-25% of our $700,000 in gain is taxable. Now, in our world, estate planning, when you die, your successor, your beneficiaries, they get what's called a step up in basis. That means in your case, with your $1 million brokerage account, the IRS, they treat you or they treat your kids like they inherited the money for $1 million, like they bought it for $1 million. So they can sell that stock and they can have no gain, or they can let it appreciate more. And if they do sell, their basis will be fair market value at your date of death. Now, if you gift the stock to your daughter, if you gift it to her, she will take your basis, your $300,000 basis in my hypothetical. So if she ever sells the stock, she'll have a ton of gain. So generally speaking, if you start gifting assets, and this goes for a house as well, you will really hurt your daughter for tax purposes. And that's kind of why no one really ever gives stuff to their kids. There's always some exceptions, and that's why we do these one-on-one appointments. But generally speaking, nobody gives stuff to their kids like this, because you will harm your child so much for taxation purposes that it's unbelievable. We're talking about hundreds of thousands of dollars. I mean, really bluntly, and I'm going to be fair about this, it's a way that a lot of poor people stay poor, is by adding people's names to their accounts, to their house. Now, I'm happy to talk about anybody one-on-one about these situations, and we can actually go through the math as to how much effect this will have. But that's why we have these one-on-one appointments. All right, so great question. I'm going to continue through this, and we will talk about more tax soon enough. Don't worry. But I do want to talk about incapacity and healthcare first, supporting documents to a trust. Do you have a durable power of attorney in place? So what a power of attorney does is it allows someone to manage your assets if you are temporarily incapacitated. If you are temporarily incapacitated, maybe you had a stroke and you're in the hospital for a couple weeks or maybe a month, it will allow someone to pay your bills. Now, like I said, that isn't a reason not to title an account to trust, because eventually power of attorney, you will get cut off if you are using a power of attorney. Do you have your proper healthcare documents in place? So 4 core healthcare documents. The first one is the Advanced Healthcare Directive. Now this directive, this is a common one. This allows somebody in your life to speak for you, to make medical decisions for you if you cannot give informed consent. Whatever that person says goes, so you better really trust that person. Do you have a HIPAA in place? A HIPAA, that's a really popular area of law right now because of COVID. This allows medical professionals to release your healthcare records with the appropriate people that you name on your HIPAA waiver. It also limits the scope of who healthcare professionals are allowed to release your medical information to. You know, I have lots of clients that want maybe their spouse and one child to receive healthcare records, but not necessarily everybody. Now, some HIPAAs, they have expiration dates on them. That's been a common theme the past year. Make sure that yours is still current. We worked with an attorney for quite some time who put a 10-year expiration on his HIPAAs. I don't know why he did that, but they're there nonetheless. So make sure that your HIPAAs are current. Do you have a pulse? Now, not everyone has a pulse. It's generally for people who are over the age of 80, I would say. This is a physician's order for life-sustaining treatment. It's also known as a DNR, so a do not resuscitate. Now, like I said, this is generally for older people, so I probably wouldn't go asking my doctor about it if I'm not over the age of 80. Healthcare directive is a lot more common. But if you want to make sure that nobody ever keeps you on tubes if you have a low quality of life or feeds you antibiotics, then talk to your doctor about a pulse. What most of us have, though, is a living will, and those are just general instructions for healthcare. Instructions to your kids, to your spouse, how you would like to be treated if you could not speak for yourself, if you were plugged in, surviving on tubes or antibiotics. All right, so that is healthcare. Healthcare is a little bit outside of the trust document, but it's really important, especially at times like these. It's important that you have your documents squared away before you actually end up in a situation where you find yourself in a hospital. Now, I totally want to shift to retirement accounts. So I had that gentleman ask earlier about his $300,000 annuity and should it be part of the trust? Well, that's going to be a long-winded answer. Let's start from the very beginning. IRAs. So IRAs, hopefully all of you have IRAs or a 401k, something similar, a tax-deferred account. Now, let's go over some ground rules. When you put money into a traditional IRA or to a 401k, you take a deduction for the year that you contribute the amount. So if you make $100,000 in a year and you put $5,000 in your IRA, you're going to pay tax on 95% of your income, the $95,000 on your income for the year. The other part's tax-free. But eventually, when you take out the money of the IRA, you pay tax, you pay income tax, so you defer the tax. And we'll talk about Roths as well, but this is the traditional IRA. Now, when you turn 59 and a half, that's when you're allowed to pull the money out. Before that, you generally pay a penalty. So 59 and a half, you take out money, you pay tax. And then what happens when you turn 72? Well, once you are 72 years of age, you have to take what's called the required minimum distribution, the RMD. So at that point, at 72 years of age, the government forces you to take money out of your IRA, a certain percentage on an annual basis from then on out, and they force you to pay tax on it. It's a very bittersweet moment in our clients' lives. Now, I'm going to skip ahead really quick. CARES Act for the year 2020. This is the COVID legislation, the stimulus package that passed. There are no RMDs for the year 2020, so you don't have to take it this year. That's a rare exception to the rule, though. Generally speaking, you take the money, you pay tax. So what happens once you pass away? Well, you pass away, and that money, if you have a spouse, your spouse rolls it over, and they take the money the same way you were. But what happens if you're a widow or a widower, or you're just single, and you leave the money to your kids? Well, your kids, when they get the money, they have to take out the money over 10 years, 10, 11 years. They have to take it out and they have to pay tax, and they have to seriously analyze how to pay that tax. Because remember, they pay tax. If they inherit $500,000 in an IRA and they pull out $500,000, they're going to have $500,000 in income for that year. Well, what if they inherit $500,000 and they let it sit there for 10 years? And after 10 years, it's worth $800,000. They take out $800,000 that year, they're going to have $800,000 in income. You combine that with how much they make it work, their spouse makes it work, they'll probably be in the highest tax bracket. Do you guys know what the highest tax bracket is in California when you combine federal and state? It is 50.3%. 50.3%. So your IRA here, in this hypothetical, your half of it potentially goes to the government. So that's not the great way to take it either. What people generally should do is take a little bit of money every single year for tax bracket management purposes. You take a little bit of money so you don't get bumped up too many tax brackets, and the remaining money inside the IRA continues to grow tax-free. Now, I'm going to talk about Roths in a little bit, but most of my clients, they seem to have traditionals. Now, this traditional IRA, some of our clients say, I want to name my trust as my beneficiary. My revocable living trust as my beneficiary. And the same thing with qualified annuities as well. They say, I want to name my trust as my beneficiary. But if you do that, the trust doesn't get 10 years to take out the money. The trust only gets 5 years to take out the money. Now, just as importantly, the trust has different tax brackets than a human. It has compressed tax brackets. So it reaches that 50.3% level at about $13,000 per year. So my point is, don't name your living trust generally. Take an appointment so we can discuss your unique situation, but do not leave your trust as beneficiary of your IRA or qualified annuity generally. Now, I still get clients though that say, I want to use a trust to pass on my IRA to my kids because whatever reason, I want to help my kids take that money slowly. I want to provide them with asset protection. And we use what's called an IRA trust. So IRA trust is a totally separate type of trust. And this is a see-through trust. You name it as beneficiary on your IRA, and your kids, they still inherit, but it goes through the trust first. Why would you want that? Well, I'll give you 3 reasons why people set them up. And the first reason is for guidance for the kids to not take that money slowly. To take the money slowly, to not take it all at once. Because you take it all at once, you're going to have that big tax bill. A lot of kids, when they inherit money, they take the money all at once because they disregard the tax rules. They just say, oh, I want my money. I want to take it. Or they do the opposite. They say, I'm going to wait as long as possible because that's what I've always been told to do with my IRAs, to let that money sit there. Well, if they do either of those strategies, the tax man's going to be the big winner. So we give that guidance as kids to take that money slowly rather than all at once. Now, a second reason is for asset protection purposes. If you just name your kids as beneficiary on an IRA, $500,000, $1 million, that money is going to be totally available in the event of divorce. Totally available if they're sued. A lot of my clients, their biggest asset is their IRA. Quite often, I have clients with bigger IRAs than they have equity in their house. And they want to make sure that their kids have some asset protection. So that if they are going through a divorce when they pass away, that IRA isn't tapped into. But the final reason why my clients seem to set up these IRA trusts, why they're so popular, is because of the control aspect. So we live in a community property state, California. There are other people that might be on here from other states. All the West Coast states other than Oregon are generally community property states. And in these community property states, you essentially have to name your spouse as beneficiary of your IRA. So we see that all the time. We see people inherit IRAs. Even if they leave the money there, they do it the correct way, they have to name their spouse as the beneficiary. My clients, if they could choose, they would not want their child's spouse as beneficiary of their IRA. If they knew that their daughter or their son was going to die with money left in that IRA, they would want that money to go to their grandchildren. They want that money to stay in their family. And that's what these IRA trusts allow us to do. They allow us to say, hey, my money, it goes to my daughter. But if my daughter dies and there's still money left in the IRA, it doesn't go to her husband. It goes to my grandchildren. It goes to them until they turn that certain age, whatever age you think is appropriate, age 30, age 35, everyone's a little bit different. But the money would be managed by the family until then, so they can at least protect their family. And like I said, IRAs, those are a lot of our clients' biggest asset, and they want to make sure they have some protection there. So IRA trusts, they're not nearly as common as revocable trusts, but they are becoming increasingly more common. If you do have questions about an IRA trust, feel free to make an appointment and we can discuss that for your particular situation. All right, I do have a new question. Let's check it out. All right, so for an IRA trust, is there a service fee every year? If you pass to a grandchild, will there be an extra generation tax? All right, this is a good question. So I'm going to praise, it's the person who asked the $1 million question. So I'm going to praise you for asking solid questions. So for the IRA trust, is there a service fee every year? The answer is no. So how it works is while you're living, if you're married, your spouse is your beneficiary. And then you name the IRA trust as the contingent beneficiary. If you're not married, IRA trust is the beneficiary. So while you live, there's no service fee. Now, once you pass away and the money goes to the IRA trust, you have a trustee over that trust. Now, maybe your trustee will be your beneficiary, but if you're somebody else altogether, that trustee gets to draw a fee every single year. So that's the closest thing to a fee. But no, our firm does not charge a recurring fee for having an IRA trust in place. Once the money is managed by a trustee draws a fee. The trustee might be the beneficiary, but not necessarily. That is a great question, so keep them coming. And then I will ask, if you pass to a grandchild, will there be an extra skip generation tax? Not unless you're obscenely rich at this point. So generation skipping tax, I'm not going to go too much into it, but there's an exemption right now, $11.58 million, same as the estate tax. So unless you're passing over $12 million to your grandchildren at this point, you're going to be fine from generation skipping. Transfer tax, once again, I encourage you to do an appointment. All right, so really that's the end of estate planning. We talked about trust, we talked about IRAs, we talked about funding, making sure your assets are in trust. Now I do want to switch over to trust administration. What happens when somebody dies and somebody has a trust? Well, unlike estate planning, when somebody walks in my office, I can size them up pretty well as far as what they're going to need. Trust administration can go in a billion different directions. what happens when somebody dies? Well, I'm going to hit on 3 key things. Number 1, we have to issue notices. Now, a lot of people don't know this, but when you write a trust, anyone you have as a beneficiary, anybody who you have as a trustee or a backup trustee, once you die, you and your spouse die if you're married, they are entitled to receive a copy of the trust. By law, they get to see a copy of the trust. And they have 120 days, I'm talking about these beneficiaries, to contest the trust. If they do not contest, or if they do not contest during those 120 days, that right is waived forever. So that is the first thing that needs to be done when somebody dies. When somebody dies, it is important to give out those notices so we can toll that time. Now, the other 2 issues with trust administration, they involve tax. And the first one's going to be those capital gains. This is the one that I talked about earlier when we had the woman ask about giving a $1 million brokerage account to her child. So when somebody dies, all their assets they have are totally stepped up. So I'm going to use a different example. Let's say that you have a house in Pasadena and the house is worth $1 million, but you bought it in the 70s for $100,000. Well, if you sell that house today, you'll have $900,000 in gain. Now, if you live in the house, you can exclude some of the gain because of the principal residence rules, but everything above that amount is going to be taxed. Now, when somebody dies in a marriage, the first spouse dies in the marriage, the surviving spouse gets a total step up on the house. That means that the house, in the eyes of the IRS, was purchased for fair market value at date of death of the first spouse. So that hypothetical I gave you, $100,000 house in the 70s, now worth $1 million. Even though they bought it for $100,000, once the first spouse dies, the IRS treats the surviving spouse like they bought it for $1 million. So that allows surviving spouse to sell and to have no gain, which is very great. That same thing happens once the surviving spouse dies. When that money goes to the beneficiaries, they get a step up again, and they can sell and have no gain. But that's not automatic. You have to make sure that you have appraisals done on your real estate, on your accounts, so that when the beneficiary does sell, they can show that they had no gain or very little gain. So appraisals, that's the next thing that happens during trust administration. So I told you trust administration, what happens when somebody dies? 3 things. Number 1, it's going to be your notices go out. Number 2, you have to make sure you're prepared for those capital gains. And then 3, the most important issue is going to be property tax issues. And that is the issue that we spend quite a bit of time on, Proposition 13. So California, for those who are not familiar or those who are a little bit just forgot the rules, Proposition 13, when you buy a house in California or any type of real estate, your property tax is based on the acquisition value of the house. It's called base year value. So as you continue to own your house and the house appreciates in value, your property taxes, they kind of go lower, I suppose, in relation at least to the value of the house. Almost every other state, they tax, property tax, the value of the house, the fair market value of the house. So, I grew up in the Seattle area. I remember a lot of older people that lived on the water, they had to move off the water because as housing prices appreciated in Washington, their property tax bills just got way too high. So they had to leave. And we don't have that in California. In California, we have these low property tax base year values for people who have owned a house for a long time. And you can pass on those low base year values to your children. On your primary residence, regardless of how much it's worth, you can pass on your property tax bill to your kids, which is a way that a lot of people keep money inside their family by passing on those low property tax base year values. You can do so on second, third, fourth properties as well, up to $1 million of base year value. Base year value is how much you bought these buildings for. So, if you bought 3 buildings for $300,000 back in the 90s, back in the 80s, you've burned through $900,000 of your $1 million in base year value. But if you buy a house today, the same house for $1 million, you've burned through all of it. So they're kind of archaic rules in all honesty, but still, if you own real estate, you have to make sure that you take advantage of them. And that's what we do during trust administration is we make sure that your kids don't get reassessed if they do not have to. And you probably know this, the county is always looking for reasons to reassess. They want more revenue. And if you give them a reason to reassess, they will do it. So make sure that your family is taken care of. Make sure that they plan properly for these property tax issues. Now, when any one of our clients, when they go through the loss of a loved one, we give out a free phone call where we can talk about the situation. Like I told you a few minutes ago, when somebody walks through my doors with estate planning, we can usually figure out what they need really quick. When it comes to trust administration, it's always a different path. Some people need a ton of guidance. Some people need protection even. Other people, they need a little bit of guidance and a little bit of protection, but you definitely need something. So call in and we can discuss what happens when somebody passes away. All right. And then finally, I do want to talk about financial planning a little bit. We work with a financial planning group called Ascent Wealth Management. A lot of our clients, they work with excellent financial planners, and that's what I want to encourage, is to work with a solid financial planner so that we can integrate your estate plan and your financial plan. When somebody dies, it's just so much easier to administrate the estate if the financial planner is on board, if they understand what's going on, if they understand a baseline of these rules. And so I do want to share one thing from Ascent Wealth Management that has taken up my first half of 2020, which is Roth conversions. So I talked about traditional IRAs just a few moments ago. I told you when you contribute money to those things, you pay tax then, or excuse me, you don't pay tax then. When you take the money out, that's when you pay the tax. Well, on a Roth IRA, it's a little bit different. You pay the tax before you contribute to the account. So I'll go back to my same hypothetical. You make your $100,000 in a year. You put $5,000 in a Roth, and then you still pay tax on the $100,000. But on the other end, on this Roth, you take out the money totally tax-free as long as you take it out past the age of 59 and a half. And there are no RMDs ever on these accounts. You can leave that money there as long as you like. And so they really are an incredible vehicle for retirement accounts. Now, I see a lot of people, like baby boomers especially, who do not have Roth IRAs, which I don't blame them. Roth IRAs only came out in the late 90s, so they're relatively new. Even when they originally were introduced in the 90s, I wasn't sure how beneficial they would be. But they are certainly something that you should have, so at least partially, in your portfolio now. The other generations, they seem to be taking advantage of it quite a bit. Personally, I use the Roth more myself than I do the traditional IRA, and that should be the last money that you ever touch. And so what I'm encouraging you to do is to consider a Roth transfer on your IRA, a Roth conversion. So what that means is you take out money of your IRA and you pay the tax on it, and then you put it back in a new account, and this new Roth account, and you never have to touch the money again unless you want to. A lot of people are doing that this year. And why is it so popular right now? Well, there's no RMD this year. So for our clients who are over the age of 72, in a normal year, if you wanted to convert money to a Roth, you'd have to pull out more than the RMD, and you'd have to pay tax, and that would be a terrible thing to do if you have a big IRA. But now there's no RMD, so any money you pull out of that IRA, you can convert to a Roth. There's no threshold. So certainly it's worth the conversation with one of us. Make an appointment, we can discuss it. I do want to touch on the final note for the Roth conversion. I told you earlier, when somebody dies with a traditional IRA and they take that money, that IRA money, the kids, they pull it out over 10 years. They really have to think about how much money they're making every single year. They have to engage on that tax bracket management. Well, if your kids inherit a Roth, they still have to pull out that money in 10 years. But they don't have to think about the taxes. The taxes have already been paid. They can just let that money sit there until year 10. And then in year 10, they can pull out the money and have no tax at all. So Roths, really incredible. I encourage you to look into them if you haven't already. All right, so that's really the end of the presentation today. I do want to wrap up before I offer the question and answer. People come to our firm all the time, and I know nobody's at our firm to see it for themselves. It's been hard the last couple of months to do this from home, but eventually our offices will open. When people walk into our offices, they're oftentimes going through the most difficult part of their lives. They've lost a spouse, or they've lost a loved one, they've lost a parent. And they have pressure from their family to do things fairly, to do things correctly. And we're able to provide them with the stability during that time. And this, like I said, it's such an important time, and you want to leave your kids the proper guidance. I do want to allow questions and answers. I had some great questions and answers come in as I was here. Let's see, does anyone want to offer questions and answers? If I don't see any come in, I will wrap up, but I just want to make sure I give people a chance to ask any questions. Okay, so I do have a question coming in so far, a question about the AB Trust. Why the AB Trust isn't necessary anymore? Well, okay, it might be necessary for some unique situations, like maybe if you have a blended family or you have a really strange assets in your family. But the reason why they're not used like they once were is because that exemption is so high. The exemption is 11.58 million. And so if you're married, that's 2 exemptions. You're up to 23 million. Now, we have a thing called portability. So portability, what that is the IRS, starting in 2011, allows spouses to combine their exemption by just submitting an estate tax return when the first spouse dies and electing portability. They don't have to split between 2 trusts. And so it's really 2 reasons why the AB trust is totally outdated. And the first reason is going to be because that exemption has jumped from 600,000 to 11.58 million. I mean, that is such a dramatic jump. I feel like if you would have asked professionals, estate planning professionals back in the 90s, would it ever be 11.58 million? And they would probably tell you, no, it will go away before it gets to 11.58 million. That's my guess. And it's just so high, and then you can combine those exemptions. So that's why the AB trust is a little bit dated. All right, I got a new question. How can I hear this session again? Lots to take in. Yeah, it is a lot to take in. I agree. So we are going to send this presentation today, I believe, to everybody who watched, and we will have a link to it. I'm also going to share my screen. Let's check out. I'm going to share my YouTube screen, and I'll share this with all of you. Just give me one sec. So I'm going to pull up my internet screen. Hopefully you can see this, and I'm going to type in YouTube. And if you go to YouTube, you can go to, I'm going to type it right on in, Cunningham Legal. And you can check out our page. And we have 47 different videos that talk about all these different things. So you can see, here's Jim talking about his deal. Here's me doing a similar Facebook Live a couple months ago, or I guess it was a month ago. We do one talking about the CARES Act in the past when it first passed. And then we have Facebook Live with Janice Lee Shin. She can talk about her opinions on trust administration and estate planning. I will also show you CunninghamLegal.com. If you go to our actual website, you can go to virtual workshops, and you will see a ton of different workshops that you can register. So the one I advertised earlier, this is going to be on May 26th, 11:30 a.m. You can register here. Jim Cunningham and I discussing the CARES Act. We did this a couple months ago. It was really popular, so we're taking a second bite at the apple. You can also check out our News and Insight, where you can see our blog posts. I write a lot of blog posts. I'm supposed to write one today about different estate planning topics. You can check out Jim's book, Savvy Estate Planning. This is the one that I said, Amazon.com. And then finally, you can check out webinars that we've already had in the past. So let's see, if I scroll down, you can check them all out and watch them. Those are all on YouTube as well, but you can check it out on our website. You can also make an appointment. It's super easy to do so. They're complimentary appointments. So you click book your free phone consultation here, and it can be via Zoom. And then you just fill out this really simple infographic, and then it goes to our team, and we reach out to schedule an appointment. All right, so I'm going to stop the screen share. I do have more questions. Okay, so let's take a look. Question and answer. So let's go down. Also, I have quite a bit of real estate. What's the best way to do the trust? I have one in place now that I got many years ago. Well, that's such a broad question. I really just encourage you to take an appointment so we can talk about it. Now, if you have a lot of real estate all over the country, generally speaking, we will deed all that real estate to your trust. Generally speaking, we will deed that real estate to the trust. If you have real estate all over the world, it's a little bit different conversation. But generally speaking, we deed all property to the trust, and we can do it all, regardless of where your property is, as long as it's in the country. All right, another question. What is California estate tax? Right now, there is no California estate tax. It's an estate tax-free state. But they always talk about putting one in place. Last year, 2019, they proposed an estate tax on people worth $3.5 million or more, $7 million if you were married, and it didn't go over very well. So it's going to be probably a little bit higher than $3.5 million, unless, of course, they really need revenue, which might be the case. So if there's another estate tax passed in the future, California estate tax, I would assume that $3.5, $7 million range is fair game. Anything above that, though, will be interesting to see. All right, I see another question. Where are you located? So we're California. We can assist you if you're in another state with a referral. But all that being said, our main offices. So I work in Pasadena. We have 2 attorneys in Pasadena, California. We have an office in Woodland Hills. We have an office in Westlake Village. We have a smaller office in Huntington Beach. And then we have offices in the Sacramento area. We have an office in Auburn, California. That's actually where our headquarters is. We have one in Roseville. We have one in Folsom. And then we have another satellite office in San Ramon as well. We are doing Zoom appointments, though. At least most of our attorneys are doing exclusively Zoom appointments. Some of us are going back to the office slowly but surely. But like I said, I work in Pasadena. All right, and then I see a chat question. How does property get funded? Does beneficiary need to be accepted if property still has an owed amount? So if you have a property, a piece of real estate, and you want to deed it to the trust, but you still have a loan, that's totally fine. We just transfer the property to the trust. The trust, or the loan on the property, that still takes place. They can still foreclose upon you. Even if you put your property inside a revocable trust, they can foreclose upon you. So it's not a big deal. Most of our clients have debt on their property, and they still are able to deed their property to their trust. That is a good question. Beneficiaries do not have to get involved when you fund a property or fund a bank account to a trust. All right, I do believe that I answered all of these questions. The annuity guy who asked at the very beginning, should it be part of the trust? I just want to touch on that since we have this question and answer session. Qualified annuities generally should not go to the trust. Qualified annuities are more common than non-qualified. Non-qualified annuities never go to the trust. Once again, if you really want these questions answered specifically, I encourage you to take a one-on-one appointment. Now, the way these one-on-one appointments work is they're generally 45 minutes, maybe an hour, 15 minutes. And we go through your estate plan. If you're married, your spouse has to be there. If you have a current estate plan, we have to see it somehow before we can really give you good advice. We have you fill out our diagnostic where we go over your assets, we go over your family situation, and we advise you. Most of the people who come to our appointments, probably the vast majority these days, they do end up becoming our clients. But not everybody does. You know, I've had plenty of great meetings where the person is totally taken care of. They have a good estate plan in place, and they just want to continue with it. And those meetings are okay too. But most of our clients do end up becoming our client after the appointment. As far as our fees go, I know a lot of people want to know about fees. Generally speaking, I would say the majority of our estate plans right now are somewhere between $3,000 and $3,500. That's the vast majority of our estate plans, but the price can be flexible as well. All right, so I don't see any more questions and answer questions coming in. I'll give somebody 30 seconds to type one. Otherwise, like I said, I do wish for all of you to make an appointment with me at a later date. If you're in Pasadena area, that's great. If not, make a Zoom. We have other offices throughout California. You are going to receive an email with this webinar in place. If you thought this was a good presentation, you know, I appreciate you coming. Please pass it on to anybody who you think can benefit. All right. Thank you very much. Have a great Memorial Day weekend.